Materia Tudor.
No government MP.
I just want to talk about the two supplementary order papers that the Green Party has put on the table. They relate directly to the review clause, which I think is clause 37 at the end of the bill. And that clause provides that the Justice and Electoral Select Committee must, after 2 years of the commencement of this legislation, review the operation of the bill. Now, the argument, the Minister has said that the reason for this is to give the time of the 2-year time period is to give the law a chance to be operational and for various experiences to be had to understand how the law may or may not be working effectively and what could be improved. She's also said numerous times, including late last night, that she is open to narrowing the time frame for that review. And so we have put on the table two supplementary order papers to change the review period from 2 years from commencement of the bill to either 18 months or 12 months from the commencement of the bill. Now, our preference is for there to be a review in 12 months, and that comes as a result of the information from the regulatory impact statement, which does describe just how many offenders they expect to be returned to New Zealand over the next period. They're saying 280 will return to New Zealand per year in the 2016-2017 year, and again in 2017-18. Plus we have the ones we have a bunch arriving on Thursday, tomorrow, and we will have more over the next few months. So there will be a large number of New Zealanders returning under the 501 Migration Act law in Australia and subject to this bill we're debating. We don't think we need to wait much longer than 12 months to see how those 100, 200 people will be affected by this legislation. There's more than enough examples of the implementation to know whether or not the law is working effectively or not and what we should be doing to change it. If the review is delayed much longer than 12 months from now, the chances of fixing the law before the next election are very slim. Now, I'll just go back and say the 2-year review currently in the bill means that the review will not start until about the same time as the general election 2017. Now, if it starts just before the general election 2017, nothing will happen over the entirety of the 3-month election period. And probably nothing until the beginning of 2018, at least, because of the time it takes to get the Parliament up and running again. So the actual review itself may well be 2.5 years away. Possibly no changes made until 3 years away, and that frankly is just too long. So let's bring the review period back to a more reasonable time frame where the process starts at least a year before the general election, gives a chance for a few months of the review by the Select Committee, and then an opportunity for government to look at the recommendations for change, to construct the legislation for change, and for that to go through the House. And as we've seen with this particular bill, we know how long the policy development can take, the drafting of legislation can take, and we don't want to be in this situation again, where we have urgency for such critical legislation that deals with human rights and the criminal law. It is a very poor process for such important legislation. So our argument is bring the review forward, make sure that it can be completed and legislation drafted and preferably passed well before the general election. That way we know both the human rights of the offenders who are returning are better protected because there is a closer review of what happens with them. There will certainly be enough examples of how the legislation affects offenders because so many will be returning in the next 12 to 18 months' time. And the lawmaking process can get back on track. Now, we want to have good quality law. We don't want to be debating law that has riddled with mistakes, and they're not intentional mistakes, it's just the consequence of a rushed job. And we are supposed to be professionals at the lawmaking business, and we can do much better, but only if the law, the review clause in this bill is changed to make sure that we have the time to do our jobs properly. And we owe it to the New Zealand public to do our jobs as best as we can. And that when we are making law about the criminal law and about human rights, that we apply all of our best efforts to the best quality job. So I would strongly recommend, Mr Chair.
Materia Toure.
So I'm strongly advocating to all parties to support preferably the 12-month review. I think that gives us the best amount of time, but even the 18-month review period at least gets us started well before the election, to support those changes, including the Minister and those government parties, because it better upholds our reputation as a lawmaking institution that will make sure we do the best and create the best possible law in these circumstances. So thank you, Mr Speaker.
The Honourable David Parker.
Thank you, Mr Chairman. Can I thank Materia Toure for those supplementary order papers, and